Take a deep breath. Tonight, we venture into the riveting intricacies of Rules 5 and 6. Prepare to be enthralled by the nuances of joinder, consolidation, and separate hearings, where the choreography of legal parties and proceedings unfolds with meticulous precision. No need to take notes. You won't remember this anyway. Now that you're comfortable, let's begin. Rule 5. Joinder of claims and parties. Joinder of claims 5.011. A plaintiff or applicant may in the same proceeding join any claims the plaintiff or applicant has against an opposite party. 2. A plaintiff or applicant may sue in different capacities, and a defendant or respondent may be sued in different capacities in the same proceeding. 3. Where there is more than one defendant or respondent, it is not necessary for each to have an interest in all the relief claimed or in each claim included in the proceeding. Joinder of parties, multiple plaintiffs or applicants. 5.021. Two or more persons who are represented by the same lawyer of record may join as plaintiffs or applicants in the same proceeding where a. They assert, whether jointly, severally, or in the alternative, any claims to relief arising out of the same transaction or occurrence or series of transactions or occurrences. B. A common question of law or fact may arise in the proceeding. Or C. It appears that their joining in the same proceeding may promote the convenient administration of justice. Multiple defendants or respondents. 2. Two or more persons may be joined as defendants or respondents where a. There are asserted against them, whether jointly, severally, or in the alternative, any claims to relief arising out of the same transaction or occurrence or series of transactions or occurrences. B. A common question of law or fact may arise in the proceeding. C. There is doubt as to the person or persons from whom the plaintiff or applicant is entitled to relief. D. Damage or loss has been caused to the same plaintiff or applicant by more than one person, whether or not there is any factual connection between the several claims apart from the involvement of the plaintiff or applicant, and there is doubt as to the person or persons from whom the plaintiff or applicant is entitled to relief, or the respective amounts for which each may be liable. Or E. It appears that their being joined in the same proceeding may promote the convenient administration of justice. Joinder of necessary parties. General Rule 5.031. Every person whose presence is necessary to enable the court to adjudicate effectively and completely on the issues in a proceeding shall be joined as a party to the proceeding. Claim by person jointly entitled. 2. A plaintiff or applicant who claims relief to which any other person is jointly entitled with the plaintiff or applicant shall join as a party to the proceeding each person so entitled. Claim by assignee of shows in action. 3. In a proceeding by the assignee of a debt or other shows in action, the assignor shall be joined as a party unless a. The assignment is absolute and not by way of charge only, and b. Notice in writing has been given to the person liable in respect of the debt or shows in action that it has been assigned to the assignee. Power of court to add parties. 4. The court may order that any person who ought to have been joined as a party or whose presence as a party is necessary to enable the court to adjudicate effectively and completely on the issues in the proceeding shall be added as a party. Party added as defendant or respondent. 5. A person who is required to be joined as a party under Subrule 1, 2, or 3, and who does not consent to be joined as a plaintiff or applicant shall be made a defendant or respondent. Relief against joinder of party. 6. The court may by order relieve against the requirement of joinder under this rule. Misjoinder, non-joinder, and parties incorrectly named. Proceeding not to be defeated. 5.041. No proceeding shall be defeated by reason of the misjoinder or non-joinder of any party, and the court may, in a proceeding, determine the issues in dispute so far as they affect the rights of the parties to the proceeding, and pronounce judgment without prejudice to the rights of all persons who are not parties. adding, deleting, or substituting parties. 2. At any stage of a proceeding, the court may, by order, add, delete, or substitute a party or correct the name of a party incorrectly named on such terms as are just, unless prejudice would result that could not be compensated for by costs or an adjournment. Adding plaintiff or applicant. 3. No person shall be added as a plaintiff or applicant unless the person's consent is filed. Relief against Joinder 5.05. Where it appears that the joinder of multiple claims or parties in the same proceeding may unduly complicate or delay the hearing or cause undue prejudice to a party, the court may a. Order separate hearings. B. Require one or more of the claims to be asserted, if at all, in another proceeding. C. Order that a party be compensated by costs for having to attend or be relieved from attending any part of a hearing in which the party has no interest. D. Stay the proceeding against a defendant or respondent pending the hearing of the proceeding against another defendant or respondent on condition that the party against whom the proceeding is stayed is bound by the findings made at the hearing against the other defendant or respondent. Or E. Make such other order as is just. Rule 6. Consolidation or hearing together, where order may be made. 6.011. Where two or more proceedings are pending in the court, and it appears to the court that A. They have a question of law or fact in common. B. The relief claimed in them arises out of the same transaction or occurrence or series of transactions or occurrences. Or C. For any other reason, an order ought to be made under this rule. The court may order that D. The proceedings be consolidated or heard at the same time, or one immediately after the other. Or E, any of the proceedings B1 stayed until after the determination of any other of them. Or 2, asserted by way of counterclaim in any other of them. 2, in the order the court may give such directions as are just to avoid unnecessary costs or delay, and for that purpose the court may dispense with service of a notice of listing for trial and abridge the time for placing an action on the trial list. Discretion of presiding judge. 6.02. Where the court has made an order that proceedings be heard either at the same time or one immediately after the other, the judge presiding at the hearing nevertheless has discretion to order otherwise. Rule 6.1, separate hearings. Separate hearings 6.1.011. The court may order a separate hearing on one or more issues in a proceeding, including separate hearings on the issues of liability and damages. A, on a party's motion with or without the consent of the other parties, or B, at a conference under Rule 50 with the consent of the parties. 2, in determining whether to order a separate hearing, the court shall consider A, whether ordering a separate hearing will dispose of some or all of the issues, shorten or simplify the rest of the proceeding, or result in a substantial saving of costs. B, whether the issues are clearly severable and can be heard separately without unduly repeating evidence or risking inconsistent findings of fact. C, whether ordering a separate hearing would unduly prejudice or advantage a party, including the impact on any counterclaim, cross-claim, or third or subsequent party claim, or in cases where a jury notice has been delivered on a party's election to have the action heard by a jury. D, the impact of ordering a separate hearing at the applicable stage in the proceeding, and any other relevant matter. All right, that's it for now. Not that anyone's still awake to hear it. I'll stay up reading so you don't have to. Good night.